Well, welcome. Hopefully everybody is tuned in and ready to listen to a little session on estate planning. Today's topic is going to be wills, trusts, and beneficiary designations. Some of the basics. Last session we talked about powers of attorney and kind of the importance of making sure that you had those things in place if you were to get ill or for any reason weren't able to handle your own matters. But again, today's topic is, okay, what happens after somebody passes away? How does an estate plan actually function? And the big thing is it depends on how their estate plan is set up. So not all estates work the same way. To start, there's a pretty big difference between wills and trusts. What the heck is a will? And what does it cover? How does it actually work?
So there's a big misconception that people have, I think, and what I hear a lot of when somebody has a will-based plan and they're thinking, oh, I have a will, it's in place, I don't have to go through probate. Unfortunately, that's not the case. So what a will is specifically, it's a list of instructions to the probate court of how you want your assets to be divided up, who you want your beneficiaries to be, and who you want to be your executor or personal representative. So the problem we see a lot of times, I think, is when people have a will plan and then they don't actually have any of their assets go through probate.
Right. But if you had a will, you said a will is a set of instructions to the probate court. So how is it that they would have assets that don't go through the probate?
And this is where beneficiary designations really come in. The problem, it's not that beneficiary designations are bad tools in of themselves, so to speak. They can definitely be used properly. But the problem is too many people have a will and then they have all of their financial assets beneficiary designated directly to the beneficiaries, which the way those work is there's sort of like a contract with the institution that holds the account that says, upon my death, either transfer this asset or pay out the asset to that individual. So that happens automatically then, as soon as they have proof of your passing. But that means that it then does not go through probate because it goes directly to that individual.
Which means then it doesn't go by the terms of the will.
Exactly.
So it becomes this question of, well, why did you do the will? What value did this will have to your circumstances? Frankly, in a lot of cases, the answer ends up being none. But one of the big problems is that people will put important planning in the will. They think they're addressing some kind of circumstance or problem that they have, or some issue with a family member, like, oh, my kids are too young to handle assets. We don't want to be passing on a substantial amount of money to them because they're not mature enough to handle an inheritance. And so I'm going to put a bunch of good terms in my will to make sure that, boy, they're not going to get that money until they're at least 25 years old. And in the meantime, their aunt's going to be in charge of it, some kind of term like that. But then the kid ends up inheriting from the life insurance policy because the beneficiary designation just says, okay, when I die, you pay to this person, my child, which means it never went into the probate. It never went by the terms of that will that you put together. And you have this kind of terrible disjointed estate plan.
Yeah.
Which is a real problem. And it's the number one mistake we see in estate plans. When we review these with clients, we have people come in, and a lot of people have done some amount of estate planning, before they've even met us, either on their own or through a different attorney. And we sit down and we go through the assets and the estate plan and talk about how this thing would actually function. And it's so common that the assets are not coordinated to actually use the estate plan correctly. And this is where we have, after the person passes away, unmet expectations, family conflict, a problem accessing funds to pay for the final expenses, all the clearing up all the debts. One of the biggest issues that I run into, and I'm sure you do too, after somebody passes away is if their estate plan is, oh, I'm going to use beneficiary designations on everything because that avoids probate. And so that's how we're going to deal with this. Well, if all of the assets go out of the estate by these beneficiary designations, there's nothing left in the estate to handle the paying for the funeral, paying any final bills, if there are any debts, taking care of that stuff. And so it becomes a real challenge, especially if there's still some real estate in the estate. Where's the money that we're using to keep up the maintenance and property taxes and any expenses on that real estate while it's getting ready to be sold? All the money left the estate. So I get these occasional, when we teach a class and we talk about this concept, a lot of times I get somebody come up towards the end of the class. Oh, well, I put beneficiary designations on everything, so that means I've avoided probate. So that was real smart, right? And it comes packaged with so many issues. We went through one or two of them there, but I could ramble on this topic for a long time. We just maybe don't have the time to talk about all the potential pitfalls. But again, beneficiary designations aren't inherently wrong or bad or anything. That is not the point. You have to use them correctly. Estate planning is not just avoiding probate. It's also avoiding all kinds of other problems that somebody could have. And a beneficiary designation, yeah, it avoids probate, but it doesn't do a lot of other things that might be necessary. And so you really want to analyze this rather than just think, oh, a beneficiary designation is some kind of simple solution.
Well, and another problem with it can be too is your will may say, I want everything to go to each child equally. But then because the parent, and I've seen this happen, the parent expects one of the children, kind of the alpha child, to be the one managing everything and paying the bills. They name them as the only beneficiary on a life insurance policy.
I've seen that one.
And now you're asking that individual whose money that's now their money, you're asking them to go about sharing it properly, the way that you wanted it to be done. And it's not saying that they wouldn't necessarily, but that could put some undue burden on them where maybe they're in a financial situation where they suddenly can't do that because creditors are now saying, well, you got this lump sum of money.
Yeah, creditors can cause a big problem. Also, if they're sharing it legally, that's just a gift from them. And so depending on the amount, they're going to have to fill out a gift tax return. If they're older, this could count as a penalizable divestment if they have to go into the nursing home within 5 years of making these gifts. So it's much more complicated than people realize when it comes to, oh, well, I'll just name it all, go into this person and they'll take care of it. A lot of times that can be a really sticky situation. I'm gonna break off for a second from our main topic and just say that all the people who have registered for the class, we had 2 handouts that we're going to be emailing to all the registered viewers. One of them is and hopefully you can see this, changes to the law and your estate plan. And this is a summary of some, certainly not all, of the different law changes that have come up in more recent years. And so we're using that as sort of a tool that we want to provide to people so that they see, okay, these are some of the things that maybe I haven't been paying attention to in the law. And, a lot of people will hear about like income tax law changes, those hit the news. Estate tax and property tax and property laws and different things, they're not particularly newsworthy. And so you have to be paying a lot of attention to understand that they're even happening. And so we've got a short summary of, again, some but not all of the law changes that affect a large portion of people. Because sometimes I hear from a client, well, I did my estate plan back in 2005, and I still have the same, basic amount of money. Maybe it's gone up a little bit if it's been invested. And I still have, the same intent, meaning, I still want it to go maybe to my spouse if I pass away and then to equal shares with my kids. And so that stuff hasn't changed since I did the plan. So what would I need to update? And frankly, there's been a lot of changes, healthcare laws, asset protection laws, tax laws, property laws. Wisconsin adopted the Uniform Trust Code in 2014, which was a substantial overhaul to all of the trust laws in Wisconsin. There's numerous things. And a lot of times we talk about how time is kind of a wear and tear on an estate plan, just like mileage is on a car. And so you have to look at these things periodically so that even if your intent hasn't changed, you want to make sure that the stuff is still working optimally so that your agents, your personal representative, your trustee, whoever you're relying on, if you become disabled or die, have the best possible options and have the smoothest experience in trying to help you, because nobody wants their legacy to be leaving a mess for their loved ones. So again, wills are sets of instructions to the probate court. Oh, you know what? I forgot the other handout.
Oh, yep.
A little disjointed here. The other handout is a personal organizer of different things that your agent is likely going to need to get their hands on if anything happens to you. And the joke I often make to my clients is, just because you made them the agent and you gave them all the right powers, it doesn't make them clairvoyant. It doesn't make them just naturally know where you do your banking and, who your doctor is and things like that. And so a little bit of organization can go a long way towards making their job as easy as possible. So those are the two handouts that are going to get emailed to all of the registered viewers today. Okay, sorry. Back into the main topic. So we just talked about how wills are sets of instructions to the probate court. Maybe talk a little bit about what the heck the probate court is and how it works.
Yeah, so the probate process is really, it's a court process, and there's kind of two subsets of it. There's an informal probate and then a formal probate. So with an informal probate, you're not really going into court and going in front of the judge. You're not sitting there arguing your case or anything like that. It's really done privately through the probate court, and having the clerk and everybody overlook things and making filings. What happens is after all the assets are, in place, so to speak, and then the will has been submitted for probate, the personal representative has to make sure that the proper filings are done, accountings, notice to creditors, things like that. So it's really kind of an oversight of making sure all of the final expenses are paid properly and the beneficiaries are paid with their due shares. If it's a formal probate, that tends to usually mean there's some reason that they actually have to be in court. Maybe it's a contested will or something like that. But the vast majority of probates that we deal with are informal, I would say.
Yeah, I mean, although estate litigation is the third largest rising area in the law, and estate litigation would essentially be, beneficiaries suing one another after somebody passes away regarding the shares or, some kind of issue. It is the third largest rising area in the law, but still the majority don't end up having a contested hearing or anything. And so if people are getting along, well, then, it can be a little smoother and not any reason to be appearing before the judge in most instances.
Yeah, and it can still be, even informal probate can still be a pretty lengthy process. I think some people don't understand how long this actually takes, but at kind of an average time frame, and this depends a lot on the complexity of the estate, what issues may come up, but kind of an average time frame is a year to a year and a half for everything to fully be probated and everything to be done, and kind of the executor just, I'm done, I'm out at this point. So,
and notice that he said average. That doesn't mean absolutely everybody it takes exactly that long. Some can be a little bit shorter, some can be a little bit longer, but I would agree with your assessment of that being about the average, because the court, everybody jumps through the same hoops when it comes to a probate. It doesn't matter if you have $50 million or $50,000, it's the same process and requirements. It's just if there's $50 million, it might take a little bit longer because there's probably more assets to get a hold of and figure out. It's probably not just 50 million sitting in one bank account. But again, everybody's running through the same stuff. We should mention that at the end of this, we're going to run through questions that we've received. So if you have anything, feel free to post, and we'll try and answer as many of them as we can in the time allotted here. Okay, so that's a little bit on what a will is, how the probate works. We kind of badmouth beneficiary designations a little more than I really intended to, but then what is a trust? I mean, a lot of times when I'm sitting down with a client and we start talking about different options and tools we might be using, a lot of the clients, this might be the first time they ever heard about what a trust is.
Yeah.
So just generally speaking, what is a trust?
A trust is really sort of an agreement that you sign. It can be with a spouse if you're married, or yourself, essentially signing off and saying, during my lifetime, I am going to own some or all of my assets, depending on how the assets are held in this trust. And then after I pass away, here's where I want things to go. It can also function as a disability plan too, saying that if I become disabled, my successor trustee is going to step in and manage my assets for me and pay for my expenses. But a trust does not go through probate. So it allows people to set up this document and have their assets held in the name of that trust. And then once they pass away, the instructions for where the assets go and how they go to those beneficiaries is followed.
Yeah, and so one way of conceptualizing it is it's almost like a will that doesn't go through probate. Now, a trust can do a lot of other things as well, but that's why it became a popular tool. It's actually initially the popularity of trusts came in really in the 1990s when they were used as estate tax planning tools. The estate tax is a whole separate tax system that very few people know much about, because it doesn't generally affect a large number of people, except for the people who are quite wealthy. And so in the 90s, that wasn't necessarily the case. In the 90s, people had around a $650,000 exemption. And that included their house and their life insurance and just everything that they owned. And so many, many, many people had taxable estates for estate tax purposes back then. And so trusts were really common planning for married couples, and then something called an irrevocable life insurance trust for married couples and single people. And that was to try and push out some number of the assets from the estate so that they weren't taxed at what used to be a 55% tax rate. So that law is very different now. Now, for estate tax purposes, we're looking at north of $11.5 million per person. So that's a heck of a lot different than 650,000.
Yes. Yeah.
And so, the question there is, okay, well then why are people doing trusts? And the answer becomes for the simplicity after people pass away in avoiding probate, but still having the types of planning provisions that a will would have allowed you to do during a probate. But hey, we don't want to be in court and have the time and expense associated with that. So that's really where they become pretty popular planning tools. So every trust in the universe, whether we're talking about a revocable trust or an irrevocable trust or even a testamentary trust, they all have three roles in them. One of them is the trust maker, and a couple of synonyms for that are a grantor or a settler. So if you're ever Googling things and you're reading about trusts, grantor, trust maker, settler, it all just means the same thing. It's the person who established the trust. Then every trust is going to have a trustee. And a trustee, in some instances, especially with revocable trusts, that is also the trust maker. And the trustee is like the manager of the property that's in the trust. They're the person that makes investment decisions and distribution decisions from the assets of the trust.
Yeah, they are not necessarily the owner of the assets within that trust. It can depend on their role. So that's a common misconception that some people have too. If they name someone else as their trustee and something happened to that trustee as an individual, does anything happen to the assets of those trusts? If they got sued for any reason or something like that. And that is, Peter's exactly right. It's more of a property manager. It's not really, they're not the owner of those assets necessarily. It can depend on how the assets are set up and what type of trust it is.
And then the final role is the good one, which is the beneficiary. And that's the person who gets the benefit of whatever property's in the trust. And on revocable trusts, most of the time, the person who established it remains the trustee and the beneficiary. So they can still do whatever the heck they want with their property, including change their trust however they want, for changes of circumstances, or just change it on a whim if you feel like, cutting somebody out or adding somebody in, or or you want to, take an opportunity to do different tax planning or whatever else, then that person can do all of those different things. So, people should understand that a trustee, the manager, it's not necessarily like a trust department or a bank or anything like that. I mean, probably more often than not, we're just using some kind of trusted family member as the backup. So maybe the person is their own trustee. Well, they still have the ability to handle their financial matters, but then they list a loved one that they absolutely trust to handle assets and the management of things. If they lose, if they themselves lose capacity. So people get confused that, it's going to be some trust department or some outside banker, but not necessarily. You can certainly use those types of services, but it's not absolutely necessary. You can pick whoever you want to have as your trustee. And you can name a backup and a backup to your backup, and you go in as extensively as you want in naming people. Should also probably make it clear that you could have simultaneous multiple trustees if the situation calls for it. So if you had 2 kids and you wanted to create sort of a checks and balances between them where they're both involved, you can name them both as your backup trustees. So there's a lot of options that can be created through these trusts. It's not necessarily you name some bank and that's your only option, and that's the way it has to go. So a lot of flexibility can be created in there. People should also understand that when you create a trust, it's not a new type of investment or a new type of like account or anything necessarily. It's really a matter of retitling the things that you own so that they're titled in the name of this trust. So, for instance, somebody sets up a revocable trust and they have, a bank account and a life insurance policy and a house. After they do the trust, they still have the same bank account, life insurance policy, and house. It's just they own it through their trust. So, and the key to this is then they don't own it in their personal name, they own it in the trust name, so that when the person dies and they don't own anything in their name, then nothing has to go through the probate court procedure. It goes by the terms of the trust, like Justin had mentioned before. And so there's a lot of different planning that people can do in their estates as well. One of the things we talk to a lot of people about is the concept of, protecting people from themselves and protecting people from others.
Right.
Maybe just a quick overview. We're going to be a little short on time otherwise.
Yeah. So what we mean by that, there's something sort of that you can do for your beneficiaries that they're never going to really be able to do with their own money. And that's when you have them inherit through either a will or a trust, as long as they're inheriting correctly with the proper terms, you can give them some creditor protection, lawsuit liability protection, divorce protection, so those kind of protections from others, so to speak, for the money you leave them, the assets you leave them.
So if you have a son-in-law that you never really liked all that much, and one of your priorities is, boy, I just want to make sure that if I pass away, he's never going to see any of this inheritance. I want to support my daughter. I love her, but boy, that guy, you can absolutely address that kind of thing through an estate plan.
Yeah, and kind of protecting people from themselves, what we're referring to with that is mostly, not people that you want to disinherit necessarily, but people you want to provide for, but for whatever reason, they shouldn't handle the money themselves, whether it's just general, they're never going to be good with money. They are always kind of not been that responsible with it. Maybe it's due to young age, You can legally inherit at 18, doesn't mean an 18-year-old should inherit $1 million and be in control of it. Yeah, so I mean, maybe put 25 or a higher age restriction of before they can actually spend the money on their own. Or sometimes it's things like substance abuse issues. It doesn't mean that you don't love your child or that you don't want to provide for them, but you, for obvious reasons, should not put them in control of that money.
Yeah. So that's just a short taste on protecting people from themselves and protecting people from others. So that's a brief overview of a little bit on how wills and trusts work. We have another session next Tuesday at the same time. So that's Tuesday, April 28th at noon. And we have our topic for that. I believe it's going to be long-term care
I believe
planning.
so, yeah.
If you've enjoyed this session, please sign up for that one. I'm going to switch gears now, and we're going to take a look at the questions that people have submitted. We should tell everybody that it's only the people who can who are participating in Zoom right now to watch this. Those are the only questions that we're going to see. So if in the future you want to be asking a question during one of these sessions, please sign up and watch this through Zoom, or else we're not going to be able to see what kind of question you might have. Okay, so one of the attendees is asking, what do you do if you loaned one of your kids money? Do they still get the same amount when you die? So that is a big, it depends kind of question, because it depends on what this loan was and how it was documented, because, and is everybody on the same page that this is intended to be a loan and not a gift? Because that's the type of thing that can end up getting litigated later of, no, mom intended for this to be a loan, but you're claiming that it's a gift and you need to pay this back to the estate. And I mean, that can be a big issue. So if it's a loan, the suggestion is that it is memorialized, meaning actually written down. Usually when we're in a situation like that, what we do is we draft a promissory note so that the terms of the loan, the length of the loan, whether or not there's going to be interest getting charged on the loan, all of those things are laid out so that if the loan has not been paid back, the kid, assuming again that this was intended as a loan and not a forgiven gift, well, then they inherit that promissory note back as part of their share when they die, so that everybody gets an equal slice, and that loan ended up being treated kind of like an advancement of the overall share of the estate. So everybody winds up equal, assuming that that is the intention of the person who passed away, the person who made that loan. So do they still get the same amount? Well, again, it depends on what the intent is, but in most instances, if it is a loan, then it would be, no, they don't get the same amount. They get their loan back because that was an advancement, and then the rest of it's equal.
Yeah, I would add to that, it is important to make sure you do memorialize that, though, because if you don't tell anybody that that is out there, and then your will or your trust just says, son or daughter gets this amount of my estate, well, they're going to get that amount of what's there. And if nobody else knows about the loan, it's not going to be taken into account.
Yeah, big problem. Big problem, but easily addressed with, halfway competent estate planning. How do I make sure my family doesn't get into fights over my money after I die? Well, that one's going to be based on circumstances quite a bit. There's a couple of general tips we can give. Number one, make sure that that you have an estate plan to begin with, that it's clear. That it's done at a time before you're, on your deathbed or anything like that, because one of the most common challenges to estate plans is whether or not the person had capacity to be signing these things. And if you're doing something other than like equal shares to the kids, the one who's getting less has a great likelihood of not liking that fact and trying to claim that you didn't have capacity because, look, they did this right before they died. And so that can turn into a very expensive litigation. So set the stuff up ahead of time so that it's not a last minute scrambling to get it right at the end kind of change.
I think, too, just kind of a general overview of making sure you're communicating these things with people.
Communication is number one. I agree.
Even as hard as it is, if you are disinheriting somebody, talking to everybody and saying, this is my intention, this was not an accident. It's not a fun conversation to have, obviously, but if everyone's on the same page, it's much less likely that anyone's gonna raise that issue later. They may be upset at the time, but they're less likely to raise that issue later.
Yeah. Communication, making sure you have clarity in the estate plan, and letting people know how this thing's going to work, what your intentions are, so that, again, it's not a big surprise at an emotional time when somebody dies. You know, if it's a surprise that they're getting a lesser amount after a death, they have a tendency to be angry and take it out at that time. But if they know well ahead of time, okay, I'm going to have a different share, they can almost kind of mourn that or whatever, where it's not a surprise at death, and a lot less likely that there's going to be a challenge to it. Okay, last question. Any positive or negatives of using LegalZoom to establish a will or trust? Well, I mean, I guess I can think of one positive, which is you know, the convenience and relatively cheap process. I mean, I'd certainly argue that you get what you pay for on that. If any of the concepts I'm bringing up or that we've talked about are in any way new to you, you know, LegalZoom is like giving like an X-ray machine to somebody who's not a doctor. I mean, yeah, this thing can create something, or it serves some kind of purpose, but if you don't know how you're using it, because you don't have a complete understanding of all of the property laws, tax laws, you know, everything else. I mean, LegalZoom sort of cop-out is, hey, you should maybe talk to a lawyer. We're providing this as a do-it-yourself service, but it's not a replacement for a lawyer. So you know, use a lawyer because we're not a lawyer.
Which, if that's the case, you might as well just go talk to the lawyer to begin with, because I can almost guarantee you that any estate planning attorney that saw a LegalZoom will would probably want to redo it anyway.
Yeah, I mean, that's been my experience. Yeah. I've had clients do some do-it-yourself stuff and have it reviewed with me. And I've never not suggested a whole number of changes because of problems that they didn't foresee, because they didn't have a complete understanding of how all of the property taxes and different laws, you know, just everything that goes into an estate plan. They don't know how every single part of it functions. And one little thing, you know, the joke about with estate planning attorney is that we, you know, tell each other all the time is there's no such thing as a smallest mistake in an estate plan, because one little thing can sink the whole ship. You know, I would really caution against using those do-it-yourself type programs, you know, Quick and Will, LegalZoom, any of that kind of stuff, unless you are, again, just absolutely confident that you know everything about how these laws and whatnot work. Because I've gone through those programs, and the explanations of what to do, because they're trying to not give legal advice. The explanations that they provide are not in my opinion, very stellar.
Yeah.
So, you know, you're going to do what you're going to do. But hopefully you've got some better sense of how some of this stuff works. So again, our class next is Tuesday, April 28th, and we're going to be talking about some long-term care concepts. If anybody is kind of needing to do any sort of estate plan, our process, you know, we're in the Fox Valley, Oshkosh, and Green Bay. Our process is we do a phone call initial consultations that normally last a couple of hours. We don't charge for those meetings. So if anybody's inclined, that's how we're doing things. Normally we would do them in person, but obviously with the travel restrictions and everything, we're trying to keep everybody safe. So we do everything remotely these days. So if anybody needs to reach out about their own particular situation, they can contact our office and schedule something. So anything I'm missing, Justin, or?
I guess the one thing I'll add is with those conferences, we do also have the availability to do a video conference if you'd prefer that. I know some
if
people
you're on
do.
video right now, absolutely.
Yeah.
Clearly, you know how to video conference. So we are all set up to do those as well. So good point. Okay, well, hopefully everybody found this a good use of their time. Again, please register for next week, Tuesday, April 28th at noon. We're going to be talking about some long-term care planning concepts, you know, trying to protect assets from long-term care expenses, why you shouldn't just deed the house over to your kid to try and protect it from, you know, getting eaten up by long-term care costs, different things like that, that usually a lot of people are pretty interested in that topic. So again, thank you for joining us, and everybody stay safe and have a good week.